Hello everyone and welcome to Field Fisher's webinar series. My name is Hazel Grant and I'm the head of our privacy practice based out of our London office. This webinar's topic is AdTech or BadTech. Before we get on to that, I've got a few words about us and also a few housekeeping points about the webinar. For those of you who don't know us, Field Fisher is an international law firm with offices across Europe, in Silicon Valley and in China. Our privacy team works across all of those offices. We are a collaborative team providing strategic and actionable privacy solutions, and I know you're going to hear about that in this webinar. Turning to housekeeping, please do ask questions as we go along, and we will try to take them at convenient points in the webinar. If not, we'll try to answer them at the end. And if failing that and we run out of time, we will definitely respond to you after the webinar by email. After the webinar, we'll also be sending a link to the recording and a copy of the slides, so please don't feel that you have to tap away desperately trying to capture all the nuggets of information that will come your way in the next hour. Please also follow our blog and keep an eye out for our further webinars. We're certainly planning one in the next week. So now let's turn to this webinar's topic and our expert speaker. So I'm going to ask Leonie Power, fellow partner of mine, to introduce herself and really get right down to the topic. Leonie, over to you.
Thanks very much, Hazel. Well, welcome everyone. Good afternoon, and thank you very much for joining our webinar this afternoon. As Hazel mentioned, my name is Leonie Power, and I'm a partner in the privacy team at Field Fisher based out of London. And we're going to talk today about AdTech or BadTech as a case study in implementing new technologies. So to begin, AdTech or BadTech, that is the question. And Hazel, if you could move on to the first slide, please. Judging by these headlines, the conclusion might be that it's very much in the realm of BadTech. Is the ICO going soft on the out-of-control AdTech industry? Privacy experts slam the UK's disastrous failure to tackle unlawful AdTech. GDPR AdTech complaints keep stacking up in Europe. And there has certainly been a fair degree of regulatory scrutiny in this area over the last 12 months or so. It's an area also that has been the focus of various complaints by activists. And from the point of view of the man or woman on the street, there is concern about the perceived creepiness factor of extensive and intrusive profile building and targeted advertising. And all of this has been exacerbated by allegations of misuse of personal data for the promotion of certain political ideals. The purpose of this session, however, is to look a little bit about at implementing new technologies in the AdTech context and mitigating risks specifically in the AdTech context. And what we will look at is, firstly, who the AdTech players are and how it all works. And secondly, we'll take a closer look at the relevant legal and regulatory landscape as it applies specifically to AdTech. And finally, we'll look at how the various players in the AdTech ecosystem, be they advertisers or publishers or other AdTech players, can mitigate risk. Okay, so looking at the various AdTech players, in the beginning, things were reasonably simple. Life in the online advertising world was straightforward. An advertiser who wanted to place an ad on a website entered into negotiations with the website owner. So it was a time of RFPs, manual insertion orders, and negotiations around price. So on our left, we have the advertiser, and on the right, as you'll just see appearing, we have our website owner, aka publisher, but equally they could be a mobile operator. So publishers generally that make available advertising inventory. There we go. So that was in the beginning when life was reasonably simple. Then things got a little bit more complicated. You had multiple advertisers wanting to place multiple ads on multiple websites. So hence the growth of ad networks And essentially, ad networks aggregated demand from advertisers and matched it with available inventory on websites. So essentially acted as an intermediary. But then things become even more complicated, and you had advertisers wanting to place ads on websites that were outside the umbrella of the ad network with which the advertiser had an arrangement. And so that brings us to where we are now. So essentially, we've had a growth of programmatic ad buying. And programmatic ad buying is essentially ad buying in an automated way using machines and real-time bidding, or RTB as it's also known. Well, RTB, in fact, is a type of programmatic ad buying. So programmatic ad buying itself involves ad buying in an automated way. RTB is a type of programmatic ad buying, and that enables the buying and selling of advertising inventory in real time on an impression by impression basis, involving an auction price mechanism. So on the publisher side, we have the supply side platforms, or SSPs, and that allows the publisher to connect inventory to multiple ad exchanges. So essentially an SSP is a piece of software that enables the selling of ads in an automated fashion. And so when an advertising opportunity arises because a user visits a particular publisher website, a bid request is issued. And this will contain some information about the advertising opportunity, including some kind of device identifier. And then in the middle, we have the ad exchange. And essentially, these are digital marketplaces that enable advertisers and publishers to buy and sell advertising space. Then on the other side of the fence, we have DSPs, or demand side platforms. And these are equivalent to SSPs, but on the buy side. So essentially what they do is they aggregate demand from a variety of sources, including ad networks. And again, a DSP is essentially a piece of software that's used to buy ads in an automated fashion. And DSPs also help advertisers to decide which ad impressions to purchase and how much to bid. And they'll do that based on a variety of factors, like, for example, the sites on which they appear and the previous behavior of the user. And they usually do this by some kind of cookie syncing activity. So for example, at its simplest, they know that cookie ID 123 that's currently browsing a news website is the same as cookie ID 567 that was browsing for shoes the previous day on a retailer website. So the DSP knows essentially that the user is in the market for shoes. And they may also know other information about the user based on the collection of personal data from a variety of sources, including potentially offline sources. So that enables the DSP to determine the value of an ad impression for a particular advertiser, and hence to determine what price to bid. So then the highest bidder wins and the ad is served. Okay, so that's a bit of a whistle-stop tour of who the key players are and how it hangs together to a certain extent. We're now going to look on the next slide at the legal and regulatory landscape. So if we look in particular at the legal requirements, we see that a number of different laws are in play. Of course, we've got the GDPR itself. We've got the e-privacy directive. We've got the various member state laws that implement the e-privacy directive, and also the member state laws that supplement and clarify the GDPR. And then there may be other laws that are also in play that we have to consider, such as the California Consumer Privacy Act. Then we've got the case law, and the case law is in the form generally of CJEU decisions, which interpret European law. So they will interpret the provisions of the GDPR and the e-privacy directive. And then we've got regulatory guidance. And I think your slide should be showing regulatory guidance and regulatory decisions. And both of those essentially give insight on as to how the particular legal requirements are likely to be interpreted. Okay, so if we focus on the legal requirements themselves, and we look more closely at some of the requirements of the e-privacy directive and the GDPR as they apply in the AdTech space. Firstly, if we look at the scope of the ePrivacy Directive, we see that it applies generally to any information, whether it's personal information or not. And that's an important point. So that when we talk about consent to the use of cookies, and I'd say at this point that a cookie is just a shorthand way of saying accessing information on a device or storing information on a device. And so when we talk about consent to the use of cookies, we're talking about accessing information generally or storing information generally, not just personal data. The scope of the GDPR, as we know, however, relates only to personal data. And we'll talk a little bit about how that's defined in the next slide. So that's the scope of both pieces of legislation, which is important to note in an AdTech context. Then we've got transparency requirements that sit across both pieces of legislation. Article 5.3 of the Privacy Directive talks about providing clear and comprehensive information to the use of cookies. In other words, clear and comprehensive information about any access to or any storage of information on a device. And so when we talk about cookies, as I say, we're not just talking about cookies, the piece of text that we understand to mean a cookie. We're also talking about things like SDKs, we're talking about pixels, any form of tracking technologies or device fingerprinting technologies. So that's the transparency requirement that as an organization, you've got to provide that clear and comprehensive information about the use of cookies. From a GDPR perspective, if there's processing of personal data going on, there are transparency requirements in Article 13 and 14 of the GDPR that require a privacy notice to be provided. And that involves providing certain statutory information about the personal data processing. That statutory information includes things like information about the identity of the controller, the purposes of the processing, the recipients of the data, and note here that it talks about recipients in a broad sense, so that could be other controllers or other processors, international transfers, etc. So we can see transparency requirements manifesting themselves in slightly different ways across the two pieces of legislation. Then we've got lawfulness requirements, and again, here, the interplay between the two pieces of legislation is quite interesting, and we'll talk about that shortly. But firstly, let's look at the specific requirements of the respective pieces of legislation. ePrivacy Directive, Article 5.3, talks about the need for consent to the use of cookies. And if we remember here again that we're talking about accessing information on a device or storing information on a device, you need consent for that, unless it's strictly necessary to provide a user requested service, or the sole purpose of such access or storage is the transmission across a network. So we can see that there are quite narrowly construed exemptions to the use to the consent requirement in relation to the use of cookies. So that's the lawfulness aspect of the ePrivacy Directive. And then under the GDPR, to the extent that personal data is being processed, as a controller, you need to demonstrate a lawful ground for that processing. Now, most commonly in an advertising technology context, that lawful ground will either be consent, in other words, that the individual has consented to the processing of the personal data, or that the processing of the personal data is necessary to perform a contract with the data subject, or the processing is in the legitimate interests of the relevant controller or a third party and isn't outweighed by any prejudice to the rights and freedoms of the particular individuals. And so those ePrivacy requirements and the GDPR requirements, they're almost always going to both be relevant in an AdTech context, because inevitably in that context, you're going to be dealing with the use of cookies, so the accessing of information on a device or the storage of information on a device. And inevitably also, when we talk a little bit more about the definition of personal data, we'll see that we're going to be dealing with personal data itself, because personal data essentially is any information relating to an identified or identifiable natural person. And when talking about identifiability, the GDPR specifically calls out identifiability by reference to online identifiers. So if it's possible to identify someone by reference to an online identifier, then you are going to be dealing with personal data. And that doesn't mean that you necessarily need to know the real world identity of that individual. It's sufficient to identify someone if you can single that individual out and distinguish them from other individuals. And you can see that in a targeted advertising context that inevitably you're going to want to single individuals out and distinguish them from others, because you're going to be serving particular targeted advertising at a particular individual. So across the AdTech space, we're almost always going to be thinking or needing to think about the requirements of the ePrivacy Directive and also those of the General Data Protection Regulation. What's quite interesting is also the interplay between both pieces of legislation. Because when we talk about needing consent for cookies, Article 2.1 of the ePrivacy, or 2F rather, of the ePrivacy Directive talks about consent being defined by reference to the data subject's consent in EU Directive 95/46 EC. So in other words, it defines consent by reference to the old EU Data Protection Directive. What Article 94 of the GDPR says is that anywhere that there's a reference to the EU Data Protection Directive 1995, that should now be replaced by a reference to the GDPR. Now, the upshot of this is that for ePrivacy Directive purposes, what that means is that when you're deciding what consent means for cookie consent purposes, then you must look to the GDPR and essentially apply GDPR standards. And significantly, we know that those standards under the GDPR are particularly high. And they talk about things like granularity of consent, consent being specific and informed, and requiring some kind of affirmative action. So quite a high standard for consent across the GDPR and by virtue of the interplay across the ePrivacy Directive requirements also. And then specifically in the context of the GDPR, to the extent that there is automated decision making that's based solely on profiling, then you need to think about Article 22 of the GDPR. And essentially what Article 22 does is that it prohibits decision making that's based solely on automated profiling that has a legal or similarly significant effect. So if we think about it in an ad tech context, the first question is, well, is there automated decision making? Well, inevitably there is. There's automated decision making about who to serve an ad on and about what the content of that ad should be. And inevitably, that's almost always going to be based solely on automated profiling that goes on behind the scenes of that particular individual. So we do have automated decision making based solely on profiling or automated profiling. The question then arises is whether that decision making has a legal or similarly significant effect. And the regulatory view in this regard is that generally speaking, for run-of-the-mill type advertising, that that type of advertising will not be regarded as having a legal or similarly significant effect. If it's, advertising for a pair of shoes or, item or similar items. However, the regulators have pointed out that there may well be situations where automated decision making that involves the targeting of advertising possibly may have a significant effect. And the examples that it gives in this particular context are, for example, serving an ad on somebody who's addicted to gambling for some kind of a gambling ad, and similarly serving an ad for high interest loans on someone who is suffering from financial difficulties. So you could see how in those particular contexts, it may well be the case that the relevant ad and the decision making involved in that ad has a legal or similarly significant effect and therefore engages Article 22. The upshot is, if Article 22 is in fact engaged, is that explicit consent would be required, because what Article 22 does is it prohibits automated decision making that has a legal or similarly significant effect if it's based solely on automated profiling, unless explicit consent is obtained or unless certain other circumstances prevail which aren't really relevant in an AdTech context. Generally speaking, what AdTech players do in this particular space in order to avoid triggering Article 22 is that they have robust advertising policies in place to prohibit certain types of advertising of the nature that we've just discussed, or any advertising that involves inferences around special category data such as health data and the like. Okay, so that's a more specific look at how the legislation per se applies to AdTech. If we move on to the next slide now, and we'll talk a little bit about the interpretation of that legislation in the form of CJEU case law. And there have been quite a number of decisions in this respect in the relatively recent past. The first of those is the Fashion ID case, and that came or was handed down on the 19th of December 2018. And this case involved an online German clothing retailer, Fashion ID, and Fashion ID had embedded the Facebook-like social plugin, so the like button on its website. And without clicking the like button or necessarily having a Facebook account, when site visitors encountered the like button, their browser transmitted to Facebook certain data, including their IP address and browser details, in order for Facebook to serve or display the like button to the user in the appropriate format. Now, certain that transmission wasn't made known to the user, and Fashion ID themselves had no control over the nature of the information transmitted, and didn't have any control over the subsequent processing or use of the data by Facebook. There were a number of questions referred to the CJEU by the German court. It's probably worth saying at this point that this decision was handed down under the EU Data Protection Directive, but its conclusions are equally valid for GDPR purposes. And the conclusion of the CJEU was that the website owner, so Fashion ID in this case, was a joint controller with the plugin provider, so Facebook, in relation to the collection and transmission of personal data. It went on to say that the website operator was also responsible for disclosing the identity and the purposes of the relevant processing by Facebook to the user at the time of collection. But the important caveat that it introduced at that point was it said, yes, the website operator must provide information to the user, but only in respect of the collection and transmission of the personal data to Facebook. It isn't responsible for providing notice in relation to any subsequent processing by Facebook because it wasn't responsible for that processing. Now, there are a number of practical implications of this decision from an AdTech perspective. The first is that it is likely that many AdTech players would be regarded by the regulators as acting as joint controllers, because even if they don't have access to the data itself, if they're facilitating access or exercising influence or control over that access, notwithstanding that they don't touch the data per se, they may still be regarded as joint controllers. And that has certain practical implications, in particular, that Article 26 of the GDPR is triggered. And what Article 26 says is that where there are joint controllers jointly determining the purposes and means of processing, there should be an arrangement between them. Now, the use of language in Article 26 is interesting because it talks in terms of there being an arrangement rather than a particular contract. But there needs, in reality and in practice, an arrangement will generally take the form of a contract. But it talks about the need to have an arrangement between the joint controllers that sets out their respective responsibilities in particular with regard to the provision of notice and with regard to the exercise of data subject rights. So that is one practical implementation, or one practical consequence of the Fashion ID decision. Another practical consequence is that Fashion ID, while it was deemed responsible to provide a notice to users about the collection and transmission of personal data to Facebook, it wasn't required to provide a notice about other processing by Facebook. So that's a point to note for AdTech intermediaries downstream from publishers. So for example, where those AdTech intermediaries want to use the personal data for particular purposes, it's really incumbent upon them to make sure that the website publishers are providing notice about those subsequent processing purposes. Now, that can often be difficult to negotiate as a matter of contract. There are other ways of doing that. It may be that mechanisms like TCF version 2 are ways that you could demonstrate an arrangement between the various parties for the purposes of Article 26 and or facilitate the provision of the relevant notice for different subsequent purposes beyond the mere collection and transmission of the relevant personal data. Right, so that's Fashion ID, and then we had Planet 49 decision, and that came down on the 1st of October 2019. The facts of that case concerned a promotional lottery. Planet 49 ran a promotional lottery on its website, and as part of entering the lottery, users were presented with two tick boxes. The first was an unchecked tick box to receive third-party advertising. And in order to enter the competition, users needed to tick this box. And the second was a pre-tick box, allowing Planet 49 to set cookies to track the user's behavior. Now, unfortunately, there wasn't any guidance as to whether the consent that was given to third-party advertising would be regarded as freely given. Because as we've said, users, in order to enter the lottery, were required to check the box that they were happy to receive third-party advertising. And so the question was, because they were forced to do that in order to enter the lottery, whether that was a freely given consent. But the CJEU didn't comment on that particular issue. However, it did comment on the point around the pre-tick box and in relation to the use of cookies. And unsurprisingly, it said, pre-tick boxes do not constitute valid consent for cookies. GDPR standard consent is required. And we saw already that GDPR standard consent talks about, the need for specific and informed consent, some kind of affirmative action. So a pre-tick box is clearly not meeting the requirement for affirmative action. Unsurprisingly, also, the court held that the consent rule applies, the cookie consent rule applies regardless of whether personal data is processed. So that ties in with the point we made earlier that the scope of the Privacy Directive is that it relates to information generally, not just personal data. So again, no surprises there. And finally, in terms of meeting the transparency and fair processing requirements of the GDPR, the court said that information should be provided about the duration of the cookie, whether the cookie would be accessed by a third party, and if so, which third parties. So quite significantly there, the point around providing the duration of the cookie. It's common enough for organizations to provide information about third parties and to identify those third parties, but not necessarily to provide information about the duration of the cookie. So that's perhaps something that organizations will need to revisit in the context of their cookie notices. Okay, so that is the case law and the interpretation of the legislation in the case law. Then in addition to that, we've got various regulatory guidances. And again, regulators have been quite prolific in this space in the recent 12 to 18 months. There have been a number of guidances issued. The CNIL, for example, issued its cookie guidance in July 2019 and has given a grace period of 12 months from that date for adherence to the standards in that guidance. More recently, in January of this year, it introduced a draft cookie recommendation. And this recommendation focuses more on practical guidance on how to obtain cookie consent. And that is subject to consultation at the moment. Back in June of 2019, the ICO issued its AdTech update, and in July 2019 produced its updated cookie guidance. And then the ADPB, the Spanish regulator, also produced some cookie guidance, as did the German regulator. Now, it's really interesting to look at these various guidances. Unhelpfully for the AdTech industry, they're not always consistent in their approach. And as a result, it's quite difficult for AdTech players, and actually more broadly for people who are implementing cookies across a number of jurisdictions, to know what the best approach is. If we look at that in more detail, we see, for example, that when it comes to cookie walls, there's a divergence in approach. The CNIL makes clear, for example, that cookie walls are not permitted. So it's not permitted to block access to a website or a mobile app by requiring consent to the use of cookies. The ICO, however, sits on the fence a little bit on this point, and it says that full cookie walls are not permitted, but partial cookie walls may be permissible. So you may be able to restrict access to specific content if users are given fully informed consent and the cookie usage is for legitimate purposes, such as to provide a service explicitly requested by the user. The ADPB, the Spanish regulator, says cookie walls are fine as long as the user is informed and they don't result in the denial of access to a legal right. Germany says cookie walls are not permissible. So quite a divergence in approach. A little bit more cohesion in terms of identifying third parties. The CNIL talks about giving an exhaustive and regularly updated list of third parties and making that list available when the user consent is obtained. The ICO talks about clearly and specifically naming third parties and explaining what they will do with the information obtained from cookies. The Spanish regulator talks about naming all third-party cookies. And Germany also talks about naming all third parties that will rely on user consent. Again, there's a little bit more cohesion on the granularity of the consent that has to be given. The CNIL says, well, yes, you can have a global consent whereby users agree to all cookies in the first layer. However, users must be able to make granular choices in the second layer about whether or not to consent to cookies for specific purposes. Similarly, the ICO says you can have a global consent whereby users agree to all cookies in the first layer. They don't spell out the need for additional granular consent, but other guidance from the ICO suggests that facilitating this granular approach would indeed be the best practice. The Spanish regulator says that you can have global consent whereby user agrees to all cookies in the first layer, but that first layer must link to a tool that enables granular consent to each category of cookie, at least grouped by purpose. Germany doesn't really comment on the issue of global consent, but says granular consent is needed, but it doesn't specify whether this should be in the first or the second layer. A lot more divergence then on the issue of continued navigation of a website and whether or not that is sufficient to amount to a valid consent. The CNIL says that, continuing to use an organization's website, so a cookie banner pops up and gives you some choices, but you nevertheless continue to use the website. The CNIL says that does not constitute a valid consent. The ICO similarly says continued navigation doesn't constitute valid consent, in particular where the user goes straight through to another part of the site rather than engaging with the cookie pop-up or banner or splash page. It says that would not be valid consent because users who fail to engage with the consent box cannot be said to have given an affirmative consent to the setting of cookies. The Spanish regulator, interestingly, however, takes a different approach and says, actually, users can indicate consent by continued navigation of a website, but only if certain conditions are met. And the German regulator rules out continued navigation as amounting to consent. Also, a divergent approach taken in relation to first-party analytics cookies. The CNIL is very relaxed about these, says that they don't need consent as long as they meet certain cumulative conditions. The ICO says, well, actually, no, technically, first-party analytics cookies are not exempt from the consent requirement, but it does make the point that they're unlikely to be a regulatory priority. Spain says analytics cookies don't require consent unless they involve the sharing of data with third parties, and even then, they don't require consent if the user can opt out of that sharing. Germany says that analytics cookies require consent, so quite a divergent approach. And finally, a little bit more cohesion again on browser settings. The CNIL says that you can't really get consent via browser settings because, again, it's very difficult to give the necessary information, and you can't give consent via browser for different purposes and in respect of different types of tracking technologies, although it does concede that that might be possible in the future. The ICO says that for now, browser settings and reliance on browser settings will not be sufficient, although it's a bit pessimistic about it will ever be possible to rely on browser settings, because it says that even if you have quite sophisticated browser settings, actually users might not always be using the most up-to-date browsers with these enhanced privacy settings. And the AEDP makes clear that consent via browser settings isn't possible. Okay, and so the final point on that, which should appear on the bottom of the slide, is the question of whether whether you need consent for processing beyond the setting of the particular cookie. So if we click on, that should arise, yes. So this is really a matter that's hotly debated. So clearly in relation to the setting of the cookie itself, by virtue of the privacy directive, you need consent because it involves either the accessing of information on a device or the storing of information on a device. But as regards what you do with that information, so the information obtained from cookies beyond the setting of the cookie, the question is whether you need consent for that. And the ICO has, for example, indicated that it may be possible to rely on another basis for processing for the use of personal data obtained from cookies beyond the setting of the cookie. But that largely depends on the type of processing. And so, for example, in an AdTech context, it's indicated that it's very unlikely that you could rely on anything other than consent for targeted advertising because of the intrusive nature of that processing. But that point is still under debate. The ICO hasn't, for example, completely closed the door on the argument that it's possible to rely on the legitimate interest ground in order to serve an ad. However, it says that it has not been convinced by any arguments that it has seen in this regard up to this point. So it remains to be seen ultimately whether that point will ever be definitively resolved. Nevertheless, we are seeing in the ad tech industry generally that because of regulatory pressure in this area and also because of other commercial pressures, there is a move towards a consent regime for the serving of targeted ads, in other words, for the use of personal data obtained from cookies, as well as for the setting of the cookie itself. Okay, so that's the regulatory guidance. And if we move on then to look at regulatory scrutiny by way of various regulatory decisions, we can also extrapolate some really interesting points about the way regulators are likely to interpret the law. There's been some quite interesting decisions from the CNIL in this regard. These decisions, so formal notices were issued against Vectuary, FizzUp, SingleSpot, and Timo. All of those DSPs, all of them were DSPs, and they essentially were processing geolocation and other personal data for ad targeting purposes in reliance on consent. So they were purporting to rely on consent for the relevant data processing for those purposes. The CNIL in all cases basically said that the consent that had been obtained was not valid. So vis-a-vis Vectory, it said that the consent wasn't specific and informed and not given by affirmative action. As regards FizzUp, Single Spot and TMO, again, said not specific and informed, and also said that the consent had not been freely given. In the case of Vectory, one significant point was that it ordered Vectory to delete the data that had been collected on the basis of invalid consent, which is a significant point in that we all tend to get very excited about the possibility of fines, but actually some of the other enforcement possibilities are quite significant from an organizational perspective also. The other very interesting point from the Vectory decision was that Vectory had in fact used a consent management tool in order to obtain the relevant consents, but the way it had implemented that tool, and in fact I think it was TCF version 1, but the way it had implemented it did not give rise to a valid consent in those particular circumstances. So bringing out an important point about implementation and adherence to the relevant policies and procedures around implementation of these types of tools. The cases against FizzUp, Single Spot and TMO were closed after those companies updated their consent collection methods. Then we'll all be familiar with the CNIL decision against Google, wherein it imposed a 50 million euro fine on Google. And again, Google, and actually if we could just go back to that slide again. So Google in that particular case had again purported to rely on consent for the processing of personal data involved in ad serving. And again, a number of comments were made around the validity of that consent. So the CNIL did not agree that a valid consent had been obtained. It pointed out that reliance on navigational or implied consent mechanisms doesn't cut it. It made some interesting points around privacy notices, and in particular that they're intended to be informational and not consent gathering documents. So in that particular instance, Google had sought consent to the privacy notice itself. And so the argument ran that consent was obtained via the privacy notice. The CNIL made the point, however, that it isn't appropriate to get consent via privacy notices because they're not sufficiently granular and the consent won't be specific and informed. And that's where it made the point about those documents not being consent gathering documents. It's worth bearing in mind in general also that requiring consent to privacy notices may cause other issues across different jurisdictions. So, for example, it may cause issues in Germany under unfair competition legislation. And generally speaking, it is more appropriate to treat a privacy notice as that, a notice, as a means of provision of information. The other very interesting point was the CNIL's commentary on the one-stop shop principle and the ability to identify a lead authority in a particular jurisdiction. Here, Google argued that, in fact, the CNIL should not be running the case, that in fact its lead authority was the Irish TPC on the basis that it had its EU headquarters in Ireland. The CNIL disagreed. It made the point that actually the decision-making in relation to the relevant processing was in fact not made by the headquarters in Ireland, but was being made in the US. And because the decision-making was outside the realm of the EU headquarters, so it was outside the place of central administration in the EU, then effectively, in this particular instance, Google could not avail of the one-stop shop principle, and the CNIL was the relevant competent authority or had competence in order to lead the investigation. Then interesting points also from the Spanish decision against foiling, imposed a 30k fine, which was reduced to 18k because of cooperation by foiling and the implementation of recommended measures. In that case, there had been a cookie banner which informed users that cookies needed to be managed via browser settings. The ADPP said that that wasn't sufficient to get the necessary consents, although it did comment that consent by continued browsing is valid if certain conditions were met. And these conditions, however, were not met in that particular instance. So some quite interesting observations and points that can be extrapolated from these various decisions as to how the law is likely to be interpreted in practice by the various regulators. Okay, so moving on then to the next slide to look a bit, make the point that actually regulatory scrutiny in this particular space is unlikely to end anytime soon. There's quite a lot of things going on. We have the Irish TPC statutory inquiry into Quantcast. We're waiting the outcome of that. There are related complaints by Privacy International into other brokers and AdTech vendors such as Criteo. Their Irish TPC is investigating Google's processing of personal data via its online exchange following a complaint by Johnny Ryan, and there's duplicate ICO complaints being made by the Open Rights Group and UCL. And then there's various complaints pending by the None of Your Business organization, which is the one in which Max Schrems is involved. There are the original complaints that were launched back on the 25th of May 2018 against Instagram, WhatsApp and Facebook. And then there's more recent complaints just in early 2020 against Grindr, Twitter, AT&T's AppNexus, OpenX, AdColony and Smato. So quite a lot happening in the space. So we expect much more or the regulatory scrutiny in this area to continue. Okay, so far we've looked at the players and we've talked a bit about the way it all hangs together. We've looked in a lot more detail at the legal and regulatory landscape. And in that regard, we looked at the legislation itself, how it's interpreted by the CJEU, how regulators have been interpreting it. And we looked in specifically at various regulatory guidances. And one of the issues was, of course, the divergence by various regulators across that guidance. In the final section, we're going to just deal briefly to finish up with some practical pointers around implementing AdTech or mitigating risk in this particular context. And I'd make the point here that we've talked about AdTech as a case study in implementing new technologies and mitigating risk in this context. Many of these points will be relevant for implementing new technologies more broadly, to the extent that those new technologies involve the use of cookies, so accessing information on a device or storing information on a device, and or the processing of personal data. Because again, you will have to think of the two different legislative regimes under the Privacy Directive and the GDPR, the interplay between the two sets of legislation, and what the cookie guidance is around implementing cookies across various jurisdictions. So these practical points will also have a broader relevance. So the first point in an AdTech world is really to understand your data protection role, because much of your obligations will hang off the fact that you are either a controller or a processor or perhaps both in some cases. And if, for argument's sake, we say that as a publisher, so as a website owner or an app owner, you are a controller, and that the other people in the chain are processors. So let's say, for argument's sake, the SSP is a processor, the ad exchange is a processor, or the DSP is a processor, then you'll need to think about, firstly, putting in place a contract with your immediate processor and ensuring the flow down of that contract to other sub-processors in the chain. And of course, that contract must contain certain mandatory terms as per Article 28 of the GDPR. You also need to think about whether any of those processors are based outside the EA in countries that are not regarded as providing adequate data protection. So you may need to overlay your Article 28 terms with standard contractual clauses. You also may need to think about whether, in fact, you are a joint controller with any other party within the chain. And we've said that given the Fashion ID case, that is indeed very possible. Regulators in general have veered towards concluding that AdTech intermediaries generally are likely to be acting as controllers, because in many cases, they will be using personal data for their own purposes. And of course, if there is a joint controller relationship, you do need to think about an Article 26 arrangement between you, dealing with your respective responsibilities vis-a-vis data subject rights and other GDPR obligations. So that's the first point, understanding your controller and processor roles. And then if we move on to looking at some of the other practical points, there are quite a number that arise in the AdTech space. So the first point we've mentioned, understanding your role. Important also as controllers to carry out data protection impact assessments. Article 35, the GDPR, requires that they be carried out if having regard to the nature, context, scope and purposes of the processing is likely to result in high risk. Now, generally speaking, in that tech context, you will be mandated to carry out a DPIA. And to the extent that as an ad tech player, you're relying on legitimate interests in order to process any of the personal data, then you need to think about whether you do a legitimate interest assessment. And these will be one of the first things that a regulator will look for if it seeks to audit compliance with the GDPR. As an advertiser, also considering data minimization strategies, and data minimization is a key principle in the GDPR. In other words, processing only the data that you need to process by reference to the relevant objective that you're seeking to achieve. As an advertiser, do you really need to know about all of the relevant advertising opportunities, for example? And then considering the legal basis for any processing that you undertake as a controller. And we've talked about this conundrum as to whether it might be possible to rely on legitimate interests as opposed to consent for ad targeting. And notwithstanding the regulatory conclusion on this, there may well be commercial drivers towards moving towards a consent regime. So, for example, Google is now requiring, that in order to integrate with many of its products in the ad tech space, a consent signal of some kind is necessary. So there may be other drivers that will push you towards a consent model rather than reliance on legitimate interests, and obviously they need to be factored into any strategy. Think about whether you need to implement a consent management platform, whether you develop your own or whether you use a third-party platform. Reviewing of contractual documentation to reflect your data protection role, respective responsibilities, and any strategy around consent or legitimate interests. Really important that there is not a sole reliance on contractual warranties. So while in your contracts, you may require the other players in the ad tech ecosystem to take certain actions, like, for example, you might require publishers to provide specific privacy notices. It's not sufficient to rely on a particular warranty in that particular instance. And the regulators have made that very clear, that you need to take proactive due diligence steps to check whether in fact valid consents are being obtained and or there are other steps being taken in compliance with the GDPR. Think about reviewing and updating your privacy notice to ensure enhanced transparency and to reflect the legal basis on which you're relying for the different processing activities. Updating your advertising policy to outlaw any type of processing that might be deemed to have a legal or similarly significant effect, or that involves inferring special category data such as health data. And then generally speaking, keeping an eye on developments, particularly following on from the ICO's update report and following on from the statement by the CNIL that they're going to prioritize the ad tech area and consider whether in some cases it may be beneficial to engage proactively with regulators. Okay, so to conclude then, we've looked at implementing AdTech as a case study in implementing new technologies. We've looked at the players, we've talked about the legislation, and we've talked about taking certain practical steps in order to mitigate risk. As Hazel said, we'd be very happy to take some questions in the last 5 minutes or so. If there are any, very happy equally to follow up on some of those questions, but thank you very much for your attention and for listening to the presentation.
Thank you very much, Leonie. That was a beautiful, clear exposition of the issues relating to AdTech. We have a couple of questions here, and I think we will have time to look into them. So if I can read out what the questions are, perhaps you can have a think, Leonie, and give us your views.
Sure.
So the first question is, could we touch on conversion cookies? They are required to fulfill a contract, e.g. payment on a user converting from a click, but this is not a contract with the data subject. What are your thoughts on this? And the questioner goes on to say, consent means that we struggle with demonstrating conversion here, and hence we cannot pay the third party appropriately. So we have another question as well. Would you like to take that one first?
Sure. I mean, this is often the conundrum with that particular legal basis, that unless you can demonstrate that the processing is necessary for the conclusion of the contract with the data subject rather than with any third party, then really you're ruled out from relying on that particular legal basis. So in the context of a conversion cookie, to the extent that it's necessary for the purposes of the contract with a third party, in other words, to determine to what extent monies are payable, then you will really, you're really ruled out from relying on the particular legal basis that it's necessary for a contract with the third party, or sorry, with the data subject, unless there's some way of otherwise showing that it is in fact necessary for the contract with the data subject. But it, in the absence of understanding the particular context, it doesn't seem like that could be the case.
So I think what we're saying there, this is a conundrum, because we will find it difficult to rely on the contractual necessity justification, and so we will be relying upon consent, and that itself might be a difficult argument to put over to an individual using a website.
I think that's right. And I suppose there is the point also that obviously when we talk about relying on a legitimate or a legal basis here for the processing of personal data, we're talking about it in the context of the GDPR, that it is necessary in any event for the setting of that conversion cookie to get consent for the purposes of the e-privacy regulation or the privacy directive rather. I mean, it might be that if you are getting consent for the setting of the cookie, you could think about an argument as to whether the subsequent processing in order to achieve the purposes of, which monies are payable to whom, you might be able to justify on a separate legal basis other than consent for the processing of the personal data. Because I guess that's one of the scenarios where you may well be able to say, look, that's not a particularly intrusive type of processing, because all we're doing is we're processing sort of some innocuous data to understand whether, where the user came from, and to determine whether there is money payable as a result of that. So assuming you've got consent to the actual setting of the cookie, there may well be arguments around that subsequent personal data processing for conversion cookie purposes.
Okay, so we have we have a few questions coming in now, but I think we probably only have time to take just one of these now. Let's go with just going with the ones that appeared in time. We have a question from someone saying, is consent required for collection of mobile advertising identifiers, such as Apple's IDFA, where the user has the ability to turn on or turn off this preference in their operating system before downloading the app and or before sharing the ID with the apps? So do you have a thought on that, Leonie?
Well, I'm wondering if the question then relates to the scenario where someone, I mean, whether you're somehow circumventing that choice of the user. But in any event, I think to the extent that you're accessing information on the device, which would include the IDFA, then that will trigger the cookie consent requirements, and as a result, you will need consent for the accessing of that information on the device. I'm not sure. I'm not sure about the point of about how it relates to, you know, the user choice over that, but
Yeah.
presumably you would get the consent via some sort of choice mechanism on the phone itself, so that, you know, that people could turn that on and off. They're either consenting or they're not consenting. Yeah, I probably might need to understand a little bit more of the context of that if further detail was needed. So happy to follow up on that if necessary.
Okay. Well, I think we are now actually out of time, so we are going to have to draw a line under it there. And thank you so much for the questions that have come through. We will respond to you by email after today's session. So thank you all for your time. Thank you, Leonie, for your lovely and clear explanation of AdTech. We'll follow up with the recording and a copy of the slides. Please do take a look at our blog and further webinars. We're planning one for next week on the issues relating to home working. We're planning to do that with our employment colleagues because we see that a lot of us are having to deal with the employment and data privacy issues and security issues relating to home working. And thank you very much again, and we hope to hear from you soon. Goodbye.
Thank you, everyone.